While the seminar proceeds, in case any participant wants to ask any question, they are requested to post the same in the chat box. All the questions would be answered after the lecture is delivered. A link for feedback form will be posted in the chat box. Everyone is requested to fill the same. Those who fail to fill the form will not be able to receive the participation certificate. I now request Dr. Payal Thaure ma'am, Assistant Professor and Head of Law, Postgraduate Teaching Department of Law, Rashtrasan Tukadoji Maharaj Nagpur University, to deliver the welcome address.
A very good morning to all of you, and my greetings to Dr. Rajesh Kumar sir, Associate Professor, National Institute of Securities Market, SEBI Undertaking, India. On behalf of Postgraduate Teaching Department of Law, I would like to extend my warm greetings to you, sir. Sir, I would like to inform you that this is our 5th webinar. We are conducting a series of webinar wherein a lot of experts we are calling, and we are discussing the contemporary topics which are really useful for the PG students so that they can understand the legal challenges, rather the challenges which they can come across into their professional lives. And today's topic which you have selected, I must say that this is one of such topic which does have a very contemporary relevance, which is abuse of dominance by big tech companies. So I'm really looking forward for this particular webinar and to get some insight. So thank you so much for gracefully accepting our invitation, for being here with us and delivering your expertise to our students. So thank you.
Thank you, madam. So good morning, everyone. Am I audible to everyone?
Yes, sir. But just before that, we would like to have your brief introduction. I think Nikita is going to do that.
Yeah. Please go ahead.
So today we have Dr. Rajesh Kumar as a resource person. Dr. Rajesh Kumar is a skilled and qualified teacher of law with more than 21 years of experience in the field of law. After completing his LLB degree from the Campus Law Center, University of Delhi in 2001, he enrolled as an advocate with the Bar Council of Delhi and practiced mainly in civil, writ, commercial, and criminal matters before the High Court of Delhi and District Courts of Delhi. Subsequently, he completed his LLM from the University of Delhi. He taught corporate and investment laws at various law colleges and universities, starting from IMS Unison Law College, Law School, Dehradun, and ICFAI Law School, Dehradun. Before joining this institute in February 2018, he was working as Assistant Dean of NLU Ranchi. During his teaching career of more than 17 years, he held various administrative responsibilities, including the position of Chief Proctor, Controller of Examination, and Assistant Registrar. He completed his PhD in Securities Law in the year 2012 from the University of Delhi. He has written many articles and 4 books on different subjects, including his books on securities law and competition law. His areas of expertise include corporate laws, securities law, corporate finance, competition law, mergers and acquisitions, banking and insurance, and international investment law. He has also participated in various conferences and seminars organized by various institutions, and he also has been a speaker in many such conferences and seminars. He teaches in various academic programs and courses conducted by NISM. Apart from teaching, he is actively involved in organizing training programs for the officers of SEBI, government officers, and the securities market regulator of foreign jurisdiction. He is also engaged in developing policy papers on various topics related to the financial markets. Today, we all are privileged to have such a knowledgeable person amongst us. So, I request you to guide us through this seminar.
Good morning, everyone. So first of all, I thank Dr. Padma and Dr. Payal for inviting me for this webinar. It's really an honor and privilege to be with you for this webinar. So today I'm just going to cover the abuse of dominance by big tech companies And how I am just going to, structure my presentation. Firstly, I will let you know what is the competition law and abuse of dominance. Then I will speak on the concept, what is the concept of abuse of dominance. Then I will take what is the relevant market and then abuse conditions. Then I will just focus on the section 4 of the Our Competition Act 2002. And then what are the factors to measure the dominance, and then power of the Competition Commission of India related to abuse of dominance, and some case laws. So this is how I will structure my presentation. Even during the presentation, if you have any question, you can ask the question. You can raise your hand and or you can type in the chat box, or post lecture you can also pose your question. So this is how we will go along. So firstly, I will just let you know what is the competition law and abuse of dominance. So as we understand that in India post independence, most of the business activities were taken by the government itself. So from 1947 to 1991, we practice this model of doing the business. All the major business activities, whether it is the mining, whether it is the banking, whether it is insurance, it was taken by the government itself. And just to follow the policy of command and control, it was believed that all the important business activities should be taken by the government itself. So to support this mind, they have enacted at that time the first law, which was known as MRTP Act 1969, where restrictive trade practices and monopolistic trade practices were prohibited, and acquiring monopoly was also prohibited. So except the government, nobody could have acquired more than 25% of the market share of a given business activity. So that was our first competition law, that is MRTP Act 1969, which was in practice from 1969 to 1991. But after 1991, post liberalization, we have adopted because the policy of liberalization, we permitted the private players in banking, private players in most of the business activities, and therefore the need was felt to enact a separate law. So the government of India constituted a committee known as Raghavan Committee, and based on the recommendations of the Raghavan Committee, the Competition Act 2002 was enacted. So that is in brief the detail of the Competition Act 2002. So there are three important ideas in the competition law. First important idea is the anti-competitive agreement. So in India, the individuals or entities can enter into an agreement, but agreements should not create an appreciable adverse impact on competition. So this is the first idea.
Sir,
Yeah.
sorry to interrupt you, but your PPT is not visible, sir.
Not visible, just a moment.
Yes, sir.
Is it visible now?
Yes, sir, it is visible now, sir.
Yeah. Thank you. Yeah. So we have the competition law 2002 actually focuses on the three important ideas. The first one is the anti-competitive agreement. Second is the abuse of dominance, and third is the regulation of combination. So in nutshell, what is anti-competitive agreement? In India, you can go for an agreement, whether it is a horizontal agreement or vertical agreement. But agreements should not create adverse impact on competition. If it creates an adverse impact on competition, then that kind of agreement can be declared as illegal by the Competition Commission of India, and penalty can also be imposed. Now, the second concept is the abuse of dominance. That acquiring in India now, as I already told you in the beginning, that under MRTP Act, a Indian business could have acquired 25, if the business is not owned by the government of India, then it could acquire only 25% of the market share. But now in the Competition Act, they can acquire the market share of the even 100% in any field. But so that is dominance. Any business can acquire the dominance, but what is prohibited is abuse of dominance. So I will, in the coming slides, I will further give you the detail. And the third important idea under the Competition Act is regulation of combinations. What is combination? Any mergers, any acquisitions, any corporate restructuring, any sort of corporate restructuring. It is subject to the law of competition. That means if it creates adverse impact on competition, then Competition Commission of India can take action on those mergers, those acquisitions, those corporate restructuring. So Competition Commission of India has been given power to act as an authority. It has the power, but it is a civil law. And the jurisdiction of the civil court is barred, like most of the corporate laws, most of the commercial laws. And appeal, if the Competition Commission take any action, then appeal is available before the tribunal and the Supreme Court. So this is how the act is structured. So now I will just come to the topic that what is the concept of abuse of dominance. So it has the three important factors. First, that the business or the entity should be a dominant entity. Then the second is the dominance should be in a relevant market. And third, there should be abuse of dominance. So as I already told you, post 1991, we adopted a policy where you can acquire dominance. That means you can acquire 100% market share if you are in a business. But what is prohibited is the abusive conduct, that you cannot abuse your dominance. As we understand that in a business, it takes number of years to be a dominant enterprise. So determining the status of the enterprise and then evaluating the conduct. That is the main task of the abuse of dominance. So what is dominance? So in law, it is defined as a position of a strength enjoyed by an enterprise, which helps the enterprise to act independently. So it can be based on the market share, very large market share of enterprise. It can be based on the economic strength of enterprise. It can be based on the other factors. So what is most important is that when you can acquire dominance, that is like not permitted, unlike MRTP Act. But what is prohibited is you cannot abuse your dominance. So what is meaning of now abuse? Abuse is when you adopt a method which can create anti-competitive harm. So then only it can be considered as abuse of dominance. So first important thing, another important thing, as I already told you in the beginning, there are three factors. First, that the entity should be a dominant entity. Second, the dominance should be in the relevant market. So what is the concept of relevant market? So under the competition law, there are two types of market. One is known as relevant product market. Second, the relevant geographical market. What is relevant product market and relevant geographical market? So relevant product market means where the products are considered as substitutes. By whom? By the consumers. On the basis of what? On the basis of characteristic, price, and intended use. So in the eye of consumers, if A good and B good are considered as substitutes with respect to the characteristic, with respect to the price, with respect to the...
Thank you.
Do you have any question? Anybody asking anything? Anybody saying anything?
No,
sir.
Yeah. Okay. So that is known as relevant market. So just to make you more clear with the help of some of the cases, that what is the meaning of relevant market. So some of the cases of the European Union are very helpful in understanding what is relevant market. So this is like first case I have just taken here, Law Hoffman versus Commission. In this case, what happened? A company was the major producer of the vitamins, vitamin A, vitamin B, and vitamin C. And company was a dominant company for the vitamin B and vitamin C. But company also produced other vitamins like vitamin A, vitamin E, vitamin K. So what policy company adopted with its wholesaler, with its dealer, with its distributor, it gave them the policy that if you take all your vitamins, then I will give you 50% discount. But if you take only vitamin B and vitamin C, then I will not give you more than 10% discount. So this policy was adopted by this company. So when this policy was adopted by the company and company was dominant in vitamin B and vitamin C, so all the wholesalers, all the dealers, they started taking all their vitamin from this company. So the competitor company, they filed a case before the competition authority in the European Union saying, sir, this is like this company is doing abuse of dominance. Company is already a dominant company in vitamin B and vitamin C. And now the company has adopted a policy of giving more discount in other vitamins if they take all the vitamin requirements. So that is taking all the business. So there, this company took the plea before the court that, sir, we are not a dominant company, because dominance has to be measured in a market, in a given market. So what is the market? Whether the market should be of vitamin B and vitamin C, or the market should be of the vitamins. So there the European court came with this formula that what, with respect to the price, with respect to the characteristic, with respect to the intended use, if the products are considered as substitutes, then all products can be considered as a part of one relevant product market. If products are not considered as substitutes, then in that case, products are not considered as the part of the same relevant market. So in this case, this formula was adopted, and it was held that with respect to the characteristic, like vitamin B and C, they can be dissolved in water. Vitamin A, D, E, and K, they only dissolve in fat. Then some vitamins are having medicinal use. Some vitamins are having industrial use. So therefore, each vitamin, finally, what the court held as, each vitamin constitute a separate relevant market. Why? Because they are different with respect to their characteristic, with respect to their price and their intended use. So that is like one of the case, where the European Union Court has tried to give the formula that what is the meaning of a market, mainly relevant product market. Similarly, in another case, United Brands versus Commission, another case where the court has tried to define what is the market in a given case. In this case, what happened? A company manufacturing banana chips had put a condition to all its suppliers that they cannot sell the banana till they are green. They cannot sell the banana till they are green. That means they cannot use the ripening process by use of chemicals, right? They cannot ripe the banana with the help of chemicals. Let the banana fruit to get ripened in the plant itself. And then only they can supply either to this company or other company. When this company adopted this policy, it created the shortage of company being a dominant company. It created a shortage of banana in the in one of the country of the Europe. So again, they filed a complaint before the competition authority saying, sir, this is like abuse of dominance, a dominant company adopting a policy. So company took the defense before the court that what is the market actually? Market, whether the market is a fruit market or market is a banana market. If the market is a fruit market, then we are not dominant. If the market is a banana market, then we are dominant. So what is the market? So there again, European Union Court applied the same formula and said that, with respect to the characteristic of banana is different from the characteristic of other fruits. The price of banana is different with respect to the price of other fruit. Availability is around the year, whereas other fruits may or may not be available around the year. So with respect to the characteristic, with respect to the price, with respect to the intended use, the banana constitute a separate relevant product market. So that is another case where the court has tried to actually define what is the meaning of a separate relevant product market. So this is like what I was just trying to explain to you, that what is the relevant market for the purpose of the competition law. So it has to be decided whether the abuse is conducted in that given market, whether the company is a dominant company in that market, and then only it can be considered as abuse of dominance. So now what are the abuse conditions? Now, of course, the company should commit some abuse. So what are the abusive conditions? So company can go for predatory pricing. What is predatory pricing? Selling the good below the price of production. If a company, established company, dominant company, try to sell the goods below the price of production or sell the services below the price of production, so it can be considered as predatory pricing. Similarly, if a company is trying to create some entry barriers, company is creating market foreclosure, company is trying to put some unfair and discriminatory condition in the purchase or sale of goods, company is trying to limit the production, technical or scientific developments, and indulge in the practices resulting into denial of market access. So these conditions can be considered as abusive conditions. Now, based on this, in India, our section 4, which deals with the abuse of dominance, was developed. So what is in the provision? In the provision is that no enterprise shall abuse its dominant position. So in India, if you are a dominant enterprise, you are prohibited to abuse your dominant position. Now, what is the dominant? What is the abuse? Again, the same concept of the US and European Union was taken in India. That if a dominant company indirectly or directly imposes unfair or discriminatory conditions, that is the abuse of dominance. If the price in the purchase of sale of goods, if it is like unfair and discriminatory price, that can also be considered as abuse of dominance. It shall also include discriminatory conditions. If a company imposes, that is also abuse of dominance. If a dominant company limit or restrict production of goods, provision of services, that is also, if it reduces technical and scientific development, or it make conclusion of contract by putting supplementary obligations. So this is how, based on the understanding developed by the other jurisdiction, India has we have drafted our section 4 of the Competition Act dealing with the abuse of dominance. So moving further, what factors are can be used, to understand that whether a company is dominant company in India or not? So that those factors are given under Section 19, Clause 4 of the Competition Act. So what are those factors? First is the market share. So if a company in India, let us say, have very high market share, it can be considered as a dominant company. So for example, HDFC Bank, ICICI Bank, State Bank of India, they are having very high market share in the banking. So they can be considered as dominant entity. Similarly, the MTNL, BSNL, Airtel, Jio, all can be considered as dominant entity. CCL, Coking Coal Limited, WCL, with respect to the sale of the coal, they can be considered as dominant entity. Indian Railway, it can be considered as dominant entity. So high market share will signify that you are a dominant entity. Then size and resources, size and importance of the competitors. So the size of the main player is having a bigger, and size of the other player with respect to their economic strength is lower. So then the first player can be considered as dominant. Then dependence on the consumer on the enterprise. So these are the factors which can be taken into consideration by the Competition Commission of India while ensuring that whether a company is a dominant company or non-dominant company. Then market structure, social obligations, social cost, relative advantage, and any other factor further. The last part is the enabling provision, where the Competition Commission of India can consider any other factor which may be relevant. So that is the residuary power, that is the extraordinary power given to the commission. So if the company is a dominant company and companies have indulged into some abuse of its market power, what are the powers of Competition Commission of India? That is given under Section 27 of the Competition Act. So any direct, what the CCI can do, CCI can direct any enterprise or association of enterprise to prohibit such abuse and pass an order. Secondly, it imposes any penalty. If a company is indulged in the abuse of dominance, it can impose any penalty, and penalty is very high. It can be the 10% of the profit of the last 3 years. So it can be very high. In one of the case, like DLF case, where the DLF in Delhi, they were doing the same thing as most of the builders were doing before RERA. They launched a product in Gurgaon, and there they have not completed the project on time. The project was not as per the sanction plan. So there the consumer made a complaint to the Competition Commission of India. So what Competition Commission of India did? Competition Commission of India held it as abuse of dominance and imposed a penalty of 6,000 crore rupees. So that kind of penalty imposition power is there with the Competition Commission of India. Then it can also award compensation, can direct that the agreement shall stand modified. It can direct that enterprise concerned to abide by such other orders, and it can recommend the central government for the division of an enterprise. So these extraordinary powers are given to the Competition Commission of India, and any such order which the Competition Commission of India deem fit. So these are the important powers given to the Competition Commission of India to actually apply or enforce the law related to abuse of dominance. Now moving to the big tech companies, which is the main topic. So in nutshell, I give you what is the Competition Act, what is the provision related to abuse of dominance. So 3 things. One is the company should be a dominant company, or entity should be a dominant entity. Second, the dominance should be in the relevant market. Relevant market, I already explained you with the help of some of the cases. and there should be abuse, whatever is given under section 4. If there is a abuse, either there is a predatory pricing, either there is a discriminatory pricing, either there is a exclusionary conduct, you are doing some trade practice with the intention to eliminate the competitor, thereby eliminating the competition, then it can be considered as abuse of dominance. So big tech companies, what are the big tech companies? As we understand, now the world is divided into two markets, physical markets and digital markets. And digital markets are growing each and every day exponentially. So each and every day, what we are witnessing, that even like for most of our requirements, we are going to a digital market rather than the physical market. So even household items we are purchasing from the digital markets rather than and there is a presence of big four companies. What are those big four companies? The Google is there, which is like a dominant company worldwide. Second is the Facebook that we all know, it's a like dominant company worldwide. Third is the Amazon, and fourth is the Microsoft. So these four companies and other companies, they are the big tech companies. They are already dominant, across the world. Why? Because they have the control over the technology. They have the control over the digital platform. They have the control over the digital markets. So therefore, they are in a position to create some sort of entry barrier for any other player. They are in a position to create some adverse impact on competition. That is the reason why the abuse of dominance cases by the big tech companies is more in issue, is more in dispute. So one such case in India, if you understand the Google, in the search engine, Google controls more than 90%, 92% across the world. So with the Android phone makers, previously, initially what the Google was, Android is an independent, platform. But what the Google has done, Google has developed a customized version of Android. And what is the rule? So when you purchase a new mobile phone, the Google gives you a choice. The Google Android gives you a choice that firstly you sign in with the help of your Gmail ID and password, and then only you can download the Google Play Store. And through the Google Play Store, you can download whatever app you want. So Google has entered into a sort of agreement with, let us say, all the mobile developers. And they said that you have to do this, then only all the applications will be downloaded. That like you also might have observed. So many other counter players like Bing is there, Yahoo is there, other DuckDuckGo is there. They have made the complaint across the jurisdictions to against Google that a Android phone manufacturer has no choice, has left with no choice. He has to accept whatever terms and conditions Google is imposing. That means if the Google is saying that you have to take this Google Play Store, and this Google Play Store is only available if you take the customized version of Google Android. So it is the norm of the business. You cannot manufacture a mobile phone without entering into a sort of agreement with Google and accepting all the terms and conditions imposed by Google. So some of the jurisdictions, the competition authority took the action against the Google, and they held the Google liable. So now what is the option given by the competition authority? They said that you have to give a choice like this, that let the customer to opt that which search engine he is opting for, whether he can opt for other search engine apart from Google. But the trouble is the Android itself is customized. The app itself is customized by the Google. Most of the applications can only be downloaded by Google. So that is what the trouble is. So looking at, in India, we have two cases of Google. One in 2018, second is 2020. So in 2018, again, the similar practice was adopted by Google. Google told all the mobile phone manufacturers in India to enter into a sort of agreement if they want to use Google Android and if they want to use Play Store, and forcing other equipment manufacturer to install entire Google suite. Right? So that is, of course, unfair. You cannot force, but that is how the choice is given. Then Google using this agreement to remain as the only supplier of the Play Store. Then what the Google does, now anyone wants to list it application on Play Store, Google charges heavy, commission, heavy fees from that player. And Google tied its proprietary app. Like certain applications are owned by Google only. Google purchased YouTube, Google purchased Chrome. So all those applications are owned by Google. So again, it is effectively reducing the choice offered to consumer. So Google further ensured that the mobile phone manufacturer could not market devices based on alternate version. So as I already told you, Android is normal, is a like open version, but Google has customized it. So if you, let us say, if a mobile phone manufacturer take independent version, then in that case, the Google services you may or you cannot use. You cannot use the services of Google Play Store. So that kind of that kind of thing was adopted by the Google in 2018. So a case was filed by an individual before the Competition Commission of India, and there the Competition Commission of India imposed the heavy penalty. But these companies are not bothered actually. Google, Amazon, Microsoft, Facebook, these companies are not bothered about with the even the penalty of 1,000 crore rupees. So that is the trouble. In another 2020 case in India of the Google, they have again imposed that you have to take if you want to list your app, if you are an app developer and you want to list your app in the Google application, then you have to pay the service fee of 15 to 30% to Google simply for using the Google Play Store. Otherwise, Google will delist your application. Or Google, so you cannot download it, so Google will ensure that you cannot download it from your mobile phone unless you are using other search engine itself. So in 99% of the mobile phone, they have, and mainly Android mobile phone, they are using the Google to Google Play only, and the search engine, they are using Google only. So Google is using it for their purpose. Then Google integrated its own Google Pay and Play Store and treated its own application differently from the other applications. Then Google adopted intent flow technology. So what the Competition Commission has done in 2018 case, fined Google with a fine of rupees 1,338 crore. And the Google went to appeal before NCLAT and then the Supreme Court. But still the fine is there. Supreme Court upheld that yes, you cannot abuse your dominant position. In the second case, again, a penalty of rupees 1,000 crore was imposed by order of the CCI dated to 25 October 2022. So again, NCLAT has upheld the order. So again, now Google will go to the Supreme Court. But this is how the Google is, abusing its market power. Google is abusing its market position in India. And so similarly, in other countries, in other jurisdictions, now what happens, if you are aware, the Epic Games, now all kids, mainly they play the different type of games, which is available on the different type of, mobile phone or the other. But if someone is, let us say, the user of iPhone, then for iPhone, again, you can only download these games through Apple Store. And again, Apple Store will charges 30% commission. And then without giving the commission, the individual, those who are using iPhone, they cannot use either of these games. So someone filed a case before, the US authority, US competition authority, saying that this is like abused by one of the, big tech company. So, but there the court did not find anything wrong in US with respect to the Epic Games. It was not find that there is anything wrong. They said that there is a choice. They can upload on their computer or non-iPhone device, where the mandate, it was not mandated that, you have to download the application with the help of the App Store. So this is the second case. Now, third important case with respect to the big tech companies, another important case is with the Microsoft case. As we understand, most of the development in the field of the computer, and mainly the Microsoft, is with respect to, so in 1959, this is the first time this computer was developed. In 1971, the IBM, this series was developed. And 1981 only the personal computer was developed. So it really took, a long years in developing the system of the computer. So when the Microsoft has developed the, computer, and when the Microsoft came with the first, Windows, what the certain conditions were imposed by, Microsoft. Microsoft said that anyone who is developing the software they were prohibited. The Microsoft initially refused to share the encryption code. Encryption code is the code which is used to develop the software on the Microsoft software. So there, the independent software developers, filed the case before the US Supreme Court. There, the US Supreme Court, put some condition and said that you cannot do this. If you do not share your platform, then of course no one in this world, can develop the other applications or other thing. So that was the another case, where so many restrictions, were imposed on the Microsoft, where the other equipment manufacturers. Then when the Internet Explorer was launched, what the Microsoft did, they said, if you are taking Microsoft, then you have to take Internet Explorer only. And so that was also questioned before the US court. They said these are the big tech companies and they are mixing both these. They are mixing the platform along with their applications. And they are prohibiting other applications, to run on their platform. And as you understand, developing a software is easy. Anyone sitting in Pune, anyone sitting in Bangalore can develop a music software, can develop a gaming software or other software. But developing Windows, it's very difficult. So that is, in another case, they said, yes, other can also, run on the Microsoft. So many cases were filed actually, across the world, whether it is the US, whether it is the European Union, and now in India also the same thing is happening, where these big tech companies are actually, these big tech companies are developing a technology and then developing a sort of monopoly or dominance, and then they are imposing the unreasonable terms and conditions. Then they are just trying to exclude the competitor from using their product unless they agree to share the bulk of the revenue. So these things are already in practice. So courts across the world, they have already prohibited the Microsoft, Google, Facebook, and Apple against those kind of abuse practices. Now the last case which I will discuss with respect to the Amazon case, it is also in the Flipkart. What they do, the self-preferencing, what Amazon does or what the Flipkart does or what this the platform does, they will give you a buy box, right? And that is the first, they are selling their product and they are making the first preference as the first preference. So others are there, other sellers are available, right? But they are giving an additional seller. So that means normally a normal customer will simply go to, okay, this pen is there, this is the price. He will add and he will purchase. So 90% of the purchase happens like this. So if Amazon is, let us say, selling its own product, right? Then of course the possibility of other product getting sold on Amazon platform is not there. Similarly, and that is always not the best price. In most of the purchases, you might have observed that whenever you are purchasing something from Amazon, something from Flipkart, something from others, that is not the best price. That means other seller price may be the lower. It may be higher or maybe the lower than the price given by the player, by the platform. But what they do, they give preferencing. They give preference to someone. They don't give preference to others, even though their prices are lower, even though their product can be better. So that is another kind of abuse which is in the practice. So again, the competition authorities across the world, they are working against that kind of practices, and that they have made that it should be like neutral. If you are owner of a platform like Google, if you are a owner of a platform like Amazon, if you are a owner of a platform like Apple, if you are owner of a platform like Facebook, you should be neutral when it comes to business. If you are like giving preference to your own product, even though other product are available, other good products are available on the lower price, so that can be a case of abuse of dominance. So now the cases are going against all these big tech companies across the jurisdictions. Now India has also joined that club, because these big tech companies are actually doing something which is abuse of dominance, which is like putting some sort of entry barrier for other, putting some sort of the supplementary obligations if other want to get the first preference. Similarly, Google, if you want to appear in the first page, you have to pay higher price to Google, then only your product will appear in the first page. Otherwise, your product will appear in the second page, third page. After second and third page, no consumer, no customer will go for it. So these kind of practices, these kind of trade practices adopted by the big tech companies, they can be considered as abuse of dominance. So with this, so that is how abuse of dominance is taken across the world. Now, if you have any question and answer, please go forward. Yes.
Sir, can you throw some light on the Amazon case? Recently, CCI slammed 200 crore fine on Amazon, sir.
Yes. So Amazon case is again, as I already told you, across the world, they are adopting this practice. They are not permitting the competitor to come and sell their product. Even if the competitor, even if let us say someone who is selling, and these platforms are nowadays selling their own product under a particular name. So the competitor product are not shown, or even if they are shown like other products, and that is very down in the list. So as a consumer will click only on the first or even another one or two, three products. So in a similar matter, the fine was imposed on Amazon. Yes, madam.
Yes, sir. Thank you, sir. Thank you so much, sir.
So any other question, if anyone wants to ask on
Yeah,
competition
yeah.
law?
Yes, sir.
Yes,
I want to ask one question.
Yeah, please go ahead.
So, can the dominant market position of the big tech companies be considered a threat to our democracy and privacy?
Not so, because the democracy, as you understand, the democracy, freedom of trade and commerce, freedom to, go for the trade and commerce, and the country, the concept of country is bigger. So, of course not, but yes, some of their trade practices may take, so they can take control of, your most of the economy. They are in a position to influence your economy. So, but not to democracy per se, because democracy is a bigger concept. We, the people of India, are capable of handling not these big tech companies, even the other countries. Forget about the companies. So I don't think the direct there is a per se threat, but yes, they can influence our economic things and economic decisions. Yeah.
Hello.
Any other question?
Thank you,
Yes.
sir.
Yeah. Hello. Can you hear me? I am Surendra here.
Yes. Yeah.
Yes, sir. Just you have quoted very good examples, but
Yeah.
you see, in cement industries and steel industries,
Yeah.
now that this market is dominated by 4 or 5 players, and they have formed the cartel,
Yes.
and resulting which the infrastructure cost is going up very tremendously. And government also is helpless to how to control them, and the government searching some another substitute for it. So have you heard any case where something
Yeah.
against or any action about that? Because they are
Yes,
very big players.
Yeah, actually in 2016-17, the Competition Commission of India has investigated into the allegations made by the different builders. And that was known as the first cartel case of India, associated cement industry and all the cement industry. What they practice, as you were saying, they have adopted. They have adopted a practice of, limiting the sale, limiting the production, limiting the supply, and thereby, increasing the demand will remain the same. So thereby, they have already, imposed a penalty of 6,000 crore on all the cement companies. So already done.
Okay.
Yeah.
They are creating artificial shortages.
Of course, all the cement companies together, they have like in that case, it was found that they have decided to reduce the production itself. So if you let us say, and every month they have made a calendar that in January only that ton of cement will be produced. In February, that much ton of cement will be produced. So if you make a calendar and reduce the supply itself, reduce the production itself, automatically the price will rise. And so that is what is abuse of dominance. If you are a dominant company and
But
only
sir,
you are there,
yeah, sir, but,
if you do this,
yeah.
yeah.
Sir,
So already
whether
this
that
case was taken. Yeah.
whether they have imposed it is a huge penalty. It was 6,000 crores.
Yes.
And
6,000 crore.
it,
Yeah,
6,000 crores is too
6,000.
much, and it is nothing for that sector. Okay, fine. Yeah, but sir, whether do you know any outcome of that case? Something.
Yeah, actually, the initially the CCI has imposed, and then they made an appeal. In appeal, I think it is pending before either NCLAT or the Supreme Court, because as you understand, in India there are hierarchy of firstly they go for appeal before NCLAT. Previously, it was Competition Appellate Tribunal, and now it is NCLAT. And after this, they will go for appeal before the Supreme Court. So it takes another 7 to 8 years. So maybe it is somewhere pending, but yes, they have to give the penalty, because it was already a clear-cut case of cartelization of the cement industry of India.
Thank you very much, sir, and nicely answered, sir. And it is good. Thank you.
Any other question?
Sir, I want to ask one more question about the gaining. Sir, how the big tech companies or big four companies, they are gaining and maintaining their dominance in the market, sir?
So actually, the trading strategy is one thing. The product innovation, they keep on doing the research and innovation, and the research and innovation, they have created something which is known as creative invention kind of thing, where they have created a market itself. Like now, Google is a market itself, Facebook is a market itself, Amazon is a market itself, along with the just having a very 10, 20 offices or 50 offices across the world. They have created a separate market. So, and every day they are doing the invention. Through the invention, they are adding some of the features, and those features are making that product different. I mean, others are also trying, like, TikTok has tried, other Twitter has tried, but they are not as successful as Facebook. So the invention, and every day they are developing something. Now Facebook came with the reel. So it was one of the feature of the TikTok. So this is how they are doing, based on the artificial intelligence, based on the consumer survey, based on the demand happening across the world. They keep on coming with the new product. That is the how they are maintaining the dominance. And the product itself is separate. Other cannot develop, because no one from 90, 50, 60 to till date, no one has even developed any product parallel with the Microsoft. So our computer opens with the the Windows. So we don't have the second choice. Whosoever is the competitor, their market share is even not raised to 10%. So 90% of the market share is owned by Microsoft. So that is, you developed a product, you keep on doing the research, you keep on doing the innovation, you keep on adding some of the features which other cannot develop, and that how you maintain your product differentiation, that your product is different from the products across the competitor. So that is how they maintain it, man. Yeah. Any other one having any question on competition law?
Sir, good morning, sir.
Yes.
This is Mayuri.
Yeah.
Sir, you have given a very good example of Amazon being dominating over other products and selling its own products.
Mm.
But we come under TRIPS agreement, sir.
Yeah.
So is there any remedy for such dominance in TRIPS, sir?
Yes, even under the TRIPS agreement, you are permitted to use your market power. You are not permitted to abuse your market power. Even when it is like, even when you are owner of, let us say, some intellectual property right, you are owner of some trade secret, you are owner of something, you are supposed to use it. Use is not prohibited by Competition Act. Abuse is prohibited. So you cannot create a market and thereby create some sort of entry barrier for others, that others cannot even come to that market. So that is what is prohibited. So TRIPS agreement actually permit the player for reasonable use of their product, reasonable use of their practices, reasonable use of their services. So that is the difference. Even if under the TRIPS agreement also, under the this intellectual property rights related thing, the compulsory licensing is the second option. If let us say somebody had monopolized over a product, somebody had monopolized over a let us say process, and it is like needed in a country, right? Suppose somebody had monopolized a medicine, and that company is only producing the medicine, and the price of the medicine is very high, then there is a choice of compulsory licensing, that you can produce it, right, by taking that license without paying that extraordinary price. But of course, you cannot use it on commercial basis. If you are using the power of compulsory licensing, then you cannot use it on. Second, the competition law. A country can make the competition law, and competition law can tell what is the use of your thing and what is abuse. So use is permitted. You are a dominant company, you can use your market power. What is prohibited is abuse of market power, right? Right, Mayuri?
Thank you, sir. Thank you very much.
Yeah. So any other question? If you have, please go ahead. Any other question if you have?
Okay, sir, thank you for enlightening us with this beneficial information. We are grateful to you for delivering this lecture and giving us a chance to be a part of it. So thank you, sir. And I now request Mrs. Padma Chobe, ma'am, Assistant Professor of Law at Postgraduate Teaching Department of Law, Rashtrasant Tukadoji Maharaj Nagpur University, to deliver the formal vote of thanks.
Good morning, everyone. I am pleased to be here on behalf of the Postgraduate Teaching Department of Law, Rashtrasant Tukadoji Maharaj Nagpur University, to convey my gratitude. Sir, actually, in our corporate law, we are saying that we have three important laws. The SEBI, we are saying that it is a Brahma, means it is a creature. Then the competition law, which is a Vishnu, we can say that it is for the fairness. And we are having the insolvency and bankruptcy code as a Mahesh, means the destroyer. So our today's resource persons, Dr. Rajesh Kumar sir, Associate Professor NISM, who very well explained one of the important law of one of the important corporate laws, which is competition law. Sir, very well explained the big four companies, big tech companies, that is Amazon, Google, Microsoft, with very good examples. So thank you very much, sir, for giving your precious time. My sincere gratitude towards Dr. Payal Thore, Madam, HOD of the department, for always supporting and guiding us. Thank you, dear colleagues, for your supporting. Thank you, all the participants, for joining us. Thank you very much.
So, thank you, madam. Thank you, madam. Thank all the students, all the participants who have joined this program. Thank you.
Thank you,
See you
Rajesh, sir.
next
It was really a wonderful lecture. So thank you so much.